Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, today we're talking about Florida lawyer again. You know, it is possible to have addictions to things that you don't ingest into your body. And that's sort of the subject about what we're talking about here. So, I'm 67 years old. I think most of you already know that. And I'll be 68 on my next birthday. Gee, you think maybe? Yeah, well, at any rate, sometimes it helps to state the obvious. And as a result of that, I'm sort of thinking about hanging up the old lawsuit, because it's time to pack it in. Let younger people do the job and learn and, maybe spend some of my time acting as a mentor to people who might need some help perhaps reaching the pinnacle of their success in the legal field. And that's sort of what I'm thinking about doing, because at some point in time, you have to let go of the day-to-day. As you get older, you sometimes get a little bit slower in how fast you walk and all of that. And it's the natural, to borrow a line from Walt Disney, it is the circle of life. Unfortunately, there are a lot of lawyers who become addicted to something that is so pernicious that once it gets them, they just can't let go. And that something is the pursuit of money. It's like, even though they have millions, it's never enough. And that's what we're going to talk about today. Let's start with this press release from the U.S. Attorney's Office in the Southern District of Florida from 2021. So this is a press release from the United States Attorney's Office in the Southern District of Florida from a couple of years ago, but it's important now because they've finally decided to indict the CEO of this company. Two South Florida securities lawyers were indicted in a fraud scheme, and the first lawyer, Andrew Dale Ledbetter, is 79, a guy who really ought to be spending his golden years playing golf, is instead going to spend the next 5 years of his life in federal prison. And by the way, he was ordered to pay $148,976,248 in restitution to the victims of the fraud scheme. And then Jan Douglas Atlas, 76, of Fort Lauderdale, pled guilty to a single count, charging him with one count of conspiracy to commit wire fraud and securities fraud. And of course, that's what Ledbetter pled guilty to as well. And he was sentenced to a term of only 8 months, and he was ordered to pay $29 million in restitution to the victims of the scheme. According to court documents, One Global was a commercial lending business that was actually just a takeoff on payday loan companies, except instead of making loans to people who couldn't make their car payments, they made loans to businesses, and they called them merchant cash advances. So Ledbetter was an attorney licensed in Florida, and he was acting as an outside counsel. And Atlas was a partner at the law firm and acted as outside counsel. And during the course of business, an issue came up as to whether or not the investment offerings that were being made to get people to invest in One Global were securities, as that's defined by the Securities and Exchange Commission. So if they were determined to be a security, it would undermine the ability of One Global to raise funds from retail investors and to continue to operate with substantial additional expenses and reporting requirements. So having to pay those and do those things would undermine the profits and fees that both Ledbetter and Atlas got from One Global. So Atlas authored 2 opinion letters in 2016 containing false information that Atlas allegedly knew would be used by One Global to operate the business unlawfully. And his buddy Ledbetter used and relied on those opinion letters to continue to raise money illegally in numerous pitches and communications to investment advisors and investors. Ledbetter was personally involved in raising more than $100 million in investor funds. And that went to One Global through it, and then he made pitches through investment advisors that he attracted to One Global. Over the years, he received approximately $3 million from One Global, the majority of which was for commissions. Ledbetter routinely held himself out to investors and investment advisors as counsel and personally vouched for them in pitches and marketing materials. So one of them got 5 years, one of them got 8 months, and they are, between the two of them, having to pay close to $200 million in restitution at a time, like I said, when they really ought to be enjoying their retirement. But instead, they're enjoying their retirement at Club Fed. So you have two miscreants here. Atlas is a guy who wrote the opinion letter. Now, opinion letters are designed to give an entity or an organization some legal cover. And basically what they're designed to do is they're designed to provide the assurance that we've run this issue past our lawyers and our lawyer says it's okay to do this. And what that usually means is that if the feds come knocking on the door and say, hey, you're breaking the law, and they wind up arresting somebody, you now have an advice of counsel defense. But there is a problem with advice of counsel defense, and one of the problems with that advice of counsel defense is that you have to disclose what you told your lawyer. And the lawyer has to disclose what he relied on in giving you this opinion letter. Let's say you ask your attorney's opinion on the issue of whether you need to pay somebody out for the full 2 weeks notice that they've given, or whether you can deduct from their paycheck a certain amount of money because you think that they have stolen money from the company and that's why you ask them to resign. Well, if you don't provide all of the information to the attorney, for example, you don't provide the information that you have absolutely no basis for making this assumption or for making this allegation against them, and that what you really know is that the reason they resigned is because they just can't stand to look at you anymore, well, then the failure to provide your attorney with that information, if your outside counsel is at an arm's length, is going to be fatal to your advice of counsel defense in a civil suit. Similarly, it would be fatal to your advice of counsel defense in a criminal matter if you didn't provide all of the information. And what would happen is the feds might very well have to go after the attorney, which is what they did here, but they did that for a different reason. And that was because the attorneys were captive to the entity, this One Global, that was making these loans and doing the things that they shouldn't have been doing. So to be clear, the way this worked is One Global used sales and marketing techniques and these lawyers to go out and recruit investors. And basically what they would do is they would go to other lawyers and other people that they knew had money and say, hey, look, we have got an absolute great investment product here. It's not really a security, but we're going to do like individual notes, sort of like certificates of deposit maybe. And you invest $100,000 and in a year we'll give you back $120,000. It'll be like 20% interest. You won't get that anywhere else. And of course, they were right, because not only did they not get it anywhere else, they didn't even get it from them. Remember, anything that sounds too good to be true probably is. Because the entire organization flopped and it went bankrupt because they were paying huge commissions to all these people who were going out and getting investors, as well as all of the people who were hooking them up with businesses who needed these loans. So when your outgo exceeds your income, guess what? You wind up on the steps of the bankruptcy court. That's what happened, and the SEC got involved because if you sell investment grade securities to individuals, you need to have an SEC broker's license and you need to be able to register those securities with the SEC. And then as a consequence of registering with the SEC, you have to provide certain information to the SEC about your investments, what the risks are, what the potential upside is, what your historical performance has been, all of these sorts of things. And if you don't do that, you've got a huge problem, because the SEC will come after you. If you don't believe me, just ask Elon Musk. He got into trouble over a tweet. So the SEC does look very hard at people who rely on public financing for their corporate endeavors. And that's what happened here. These folks went out of their way to gather investors, and now, basically a $300 million loss for all those investors. Well, you got a lot of really hot people out there who may have lost significant amounts of money, maybe significant parts of their retirement income. These guys targeted people who had IRAs. Now, I'm sorry, but that's about as low down as you can get. An individual retirement account where somebody is going to use that money to help defray expenses after they're sort of, hogtied into Social Security, and then you steal that money from them. That's lower than whale dung, so to speak. So as a result, the guy who did a lot of the marketing and who actually went out and got the investors, he wound up with a 5-year prison sentence and having to pay back $148 million. And the guy who wrote the opinion letter, who is absolutely clear, and both of these lawyers have been disbarred, so the federal bar and the state bar have both kicked them out. One of them is permanently disbarred. The other one is disbarred with leave to reapply. It's a bad situation for these folks, but the bottom line is they're never going to work as lawyers again, at least not with any respect. And perhaps, that really implicates how much work they are going to have to do to make those restitution payments. Because unless they were already sitting on $148 million in the bank at the time of this case, they probably do not have the funds necessary to pay all of that restitution, which means houses, cars, things like that are going to be taken and sold and try to make the investors whole again. Now, they went through bankruptcy, so perhaps some of that restitution will be taken care of in bankruptcy, but often that's not the case because, again, it's an intentional act. When you commit a crime like this, it's an intentional act, and it is possible for the federal court, the federal bankruptcy court, to say, no, we're not going to discharge this debt because you did criminal acts. So that's what I have for you today. It's kind of an interesting story. It should give you at least a little bit of confidence that there is somebody out there, the SEC, looking after small investors. And in this context, they looked after them, but they didn't quite get there in time to stop this. The whole thing is set up. The SEC is set up to protect people, but it only works when people comply. And when people don't comply, it doesn't work. So if anyone ever offers you an unregistered security, you should immediately go to the SEC and tell them, because you may very well be saving a lot of other investors a big-time headache. That would be a kindness you could do if you ever have that problem. You know what I always say, try to do a kindness today. Thanks for watching. We'll catch you on here next time down here at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.